Hi friends, I'm Chelsea Grayson coming to you once again from the Office of the CEO. This is my show where I can help you be more successful in your current career, and I can also help you successfully transition to a new career. So today I'm going to give you another quick bite. This is a continuation of the episodes that I've been doing on understanding a legal agreement so that you can make sure that when you memorialize your deal, it's being memorialized accurately, and so that you'll have a document that sets forth the blueprint for how the parties are supposed to perform during the course of the deal and even afterwards. And I've been alluding to the episode that I'm doing today for a while. So this will be the start of several episodes on the so-called boilerplate or miscellaneous section. So this is the section that's generally the very last section of any legal agreement. It comes just before the signature pages, and it sort of sets forth the rules of the road when it comes to engagement and interpretation of the legal agreement. Unfortunately, because it's been called the miscellaneous section, sometimes it's called the general provisions section, and sometimes it's just called boilerplate. A lot of folks that are parties to a legal agreement sort of skip over this section. They kind of skim over it. They say, okay, the right provisions are there that should be there that'll sort of govern the rules of engagement. But because this doesn't have anything to do with payment, performance of payment, performance of duties and obligations, because this isn't necessarily a section where I'm representing something about the state of my organization, because it isn't describing the meat and potatoes of the deal, I can sort of glance over this, make sure everything's there, and just sort of skip by. But that is absolutely not the case. You absolutely need to do your work in this section. It contains a lot of important provisions that if you're just borrowing them from a previous legal agreement and you haven't tailored them specifically to the parties of this agreement and specifically to the deal that's being set forth in this agreement, they can be incorrect, they can be totally inapplicable, they can actually hurt one or both of the parties to the agreement. Sometimes folks will try to sneak in some tricks here, and so they'll try to sort of take an advantage in the agreement in sort of a sneaky way because they know that most folks don't particularly read this section too carefully. And a lot of times, again, because parties know that folks sort of glance over this section very quickly, they'll not just try to put sneaky tricks into the sort of typical provisions that would be in this section, but they'll also try to put really important provisions into this section that really ought to be in the more substantive, so-called deal parts of the agreement, but they'll sneak it in here. So you absolutely must do your work on this section, and that's why I'm going to take several episodes to go over the various provisions that are set forth in this section. So let's just go over a few right now. I've written a couple down. So a lot of times folks will try to put a press releases and announcements provision in this section. So this is a provision that talks about, look, if there's going to be a press release, this is the form it has to be in. If there's going to be a press release, we don't have a form drafted right now, but the parties will agree in writing as to what the press release is going to say. Or there must be a press release, or there absolutely will not be a press release. Sometimes even there's going to be a press release. Party A gets to cut the first draft. Party B can weigh in on what Party B likes or doesn't like about the press release, but ultimately it's up to the reasonable discretion of Party A to put the press release together as they see fit. So Party B doesn't necessarily have the right to revise, they just have the right to weigh in and comment, and then Party A, at their reasonable discretion, can decide whether or not to take those comments. So, and this provision also goes to other sorts of public announcements, right? Whether we're talking about SEC disclosures that may or may not be required by one or both of the parties. Again, if a party is public, they'll usually have to make some sort of an SEC disclosure about the deal. If it rises to a certain level of materiality, you'll want to have agreement as to how that's going to be drafted, who's going to file that announcement. And especially in this world where there's tons and tons of media platforms that people can get on, anywhere from all the social media platforms on down the line, you'll always want to put guardrails in place between the parties about what they can and cannot discuss about this agreement publicly. Now, this is separate usually from the confidentiality obligations that each of the parties agrees to when they enter into a transaction. That confidentiality provision, which is sometimes set forth in a separate agreement that's attached to the main purchase agreement or to the main transaction agreement, will really set forth the hardcore rules of the road in terms of what are the terms of this deal that are strictly confidential, that can never get publicly announced. For example, there might be discrete monetary economic terms that folks don't want publicly announced. What are things that we are allowed to talk about, and then in what venue are we allowed to talk about things? What if we are required by a governmental entity to talk about something, or if we're subpoenaed in a court case, a piece of litigation, for example? What do we have to do in that situation? Do we have to notify the other party that we've been required by a governmental agency or a court of law to make a disclosure about the nature of this agreement? And in that case, what are the other party's rights? Do they get to come and argue in court that something shouldn't be disclosed? Do they merely have the right to be notified that there is going to be a disclosure because it's a requirement in court, for example? So public press releases and announcements and confidentiality obligations are two things that you might see in the so-called miscellaneous section of a legal agreement. They're usually two separate provisions. They both talk about how, when, what, why, of what can we talk about in respect of this deal, the parties to the deal, the terms of the deal, and in what venues can we do it. Okay. I hope you guys all see without further explanation why that is such an important provision and why you really want to take a look at it, especially to the extent that you care about whether or not something gets disclosed from the deal and how it gets disclosed and who gets to disclose it. Okay, so another very important provision that you'll see in the so-called miscellaneous section is usually called the entire agreement provision or the entirety clause. And that's just a fancy legal jargon way of saying, look, we've got this agreement here, the four corners of this agreement that we've just negotiated for days, weeks, months on end. We know what's set forth in this agreement, painfully so sometimes. We've been over every single nook and cranny of this agreement. But we've got other agreements that we've entered into concurrently with this one. Or maybe we have a letter of intent that we entered into just ahead of getting into this legal document. Maybe we had a previous agreement that we were parties to that memorialized the first parts of this deal, but then we decided to scrap that agreement, terminate it, and we're going to go with this agreement instead. There's all sorts of other things, and maybe we've just had conversations at the coffee shop or at a bar ahead of this, and maybe we did a back of the napkin scratch, or maybe we just had conversations, maybe we've texted. There's all sorts of other conversations, interactions, writings, whether formal or informal, that parties have between them when they finally get to an inked formal agreement. And it is up to the parties in the so-called entire agreement or entirety clause of a legal agreement to say what is actually a part of our understanding with each other and what is not. What are we formally declaring counts between the two of us and what doesn't count? So again, if we previously had an agreement and this one is supposed to replace that, we will say that very specifically here. This supersedes that. If we separately have a non-disclosure agreement between the two of us, we'll say that non-disclosure agreement comes in as part of the understanding between the parties here. It is in full force and effect. If there's an employment agreement that was signed concurrently, that might come in as well. You also might say, also there's some schedules or attachments to this document, and those are included in the body of this document and in the understanding between the parties. So again, this really helps, for example, when parties have done a back of the napkin conversation in a bar or a restaurant, right? That was the first interaction they had with each other when they were saying, hey, maybe we should enter into a transaction. But since then, it's been months. The parties have come to different business terms. We're still coming together to do a deal, but we've now negotiated a lot of terms. Some of those things might still be around. Some of those things might not be part of the deal. This is the deal we're inking. We are saying that back of the napkin conversation or that actual back of the napkin document does not count. That is no longer in full force and effect. This document is the one that captures the deal between the parties. I hope you can also see how incredibly important the entirety provision is so that you don't pull in things that folks just casually talked about within their first couple of meetings, for example, and don't try to incorporate those things into the actual deal that you all signed after a hard-fought negotiation. All right, so I think that does it for today's episode. I've got many, many more provisions that are usually in the so-called miscellaneous or general provisions section of a legal agreement to go over with you guys. So be sure and subscribe to my YouTube channel so you don't miss those and other future episodes. And I will see you next time from the Office of the CEO.